Oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1369, Secretary of Labor, Mine Safety and Health Administration, Petitioner versus M-Class Mining LLC and Federal Mine Safety and Health Review Commission. Ms. Maltz for the petitioner, Mr. Chandler for the respondent, M-Class Mining LLC.
Hi, good morning, counsel. Just as a matter of convenience, Judge Henderson has asked me to preside, but she is with us through a conference call. So, counsel, please proceed.
Good morning. May it please the court. I'm Susanna Maltz for the Secretary of Labor. I'd like to reserve 2 minutes for rebuttal, please. Thank you. Thank you. Section 103K orders give MSHA complete control over a mine in the event of an accident. They're among the agency's most powerful tools because they're used to rescue miners and to prevent deaths and injuries. Here, MSHA properly exercised its plenary power under Section 103K when it took control of the M-Class number 1 mine after a miner was diagnosed with carbon monoxide poisoning. Unless the court prefers otherwise, I'll begin with the mootness issue, and then I'll move to the standard of review issue, and then I'll very briefly touch on our argument that even if the commission selected the appropriate standard of review, they misapplied it.
All right.
So turning to mootness, it's the Secretary's position that this case is moot. The commission was not able to give M-Class any effective relief when it terminated, or excuse me, when it vacated an already terminated K order. When MSHA terminated that order, M-Class was able to use its air compressor again. When the commission later vacated that order, there was no material change, and M-Class did not get any additional material benefit. And to the extent
so
that
did it not get the benefit of not having that accident order? Right?
So it had, yes, there was no longer a terminated K order on the mine's compliance history.
That's right. And furthermore, it got its equipment back. And before that, the order had held all that up, correct?
No, Judge. When the order was terminated, it got its equipment back. When the order was later vacated, it had already had its equipment back.
No, my point is when the order issued, it lost control of its equipment, correct? And so your point now is that the commission has vacated the order, the case is moot?
Our position is that once the order was terminated, the case was moot. Vacature didn't additionally change anything.
There's a mine safety retrieval system or data system.
Yes.
And the commission's order was not stayed, was it? The vacating order?
No.
No. Yeah, and yet the mines, the 103 order is still reported in the data system. Does the secretary have any expungement procedure?
I believe that once the order is vacated, it is expunged from the data system. It's
but
no
that
longer
hasn't happened with this order. We checked, and it's still on the data retrieval system.
I was under the impression that it has been expunged. There are other terminated orders in the compliance history, and so if it is there, I'm not sure why. Vacature typically removes those orders from the compliance history.
And you have a regulation that says that?
No, I just think that that's typical agency practice.
Well, based on what?
Based on
speculation and oral argument, as I understand it. I understand you're making your best argument, but that's what it is, isn't it?
Yes, Your Honor, that is what it is.
All right.
As far as I know. It is the Secretary's position, though, that removing that order from the compliance history did not actually confer a non-speculative benefit to M-Class. They argue that their reputation would be vindicated should that order be removed from the compliance history. And I have 2 points in response to that. First, reputation isn't a cognizable interest under the Mine Act. And second, the fact of a terminated K order on a compliance history doesn't suggest wrongdoing. It doesn't suggest that M-Class was responsible for an accident. It only, as the commission says, suggests that something occurred at the mine. And so
let me ask you, just a hypothetical. Suppose a mine operator is closed down when an accident order issues because a doctor said he thought this patient was suffering from carbon dioxide poisoning. All right. And so the inspector operates on that basis of that information, shuts the mine down, and months go by. And the mine operator is trying to get his equipment back, trying to get the agency to act, and nothing happens. As I understand the secretary's position, she can avoid any judicial review by terminating that order, even if, in my hypothetical, it was irrational, or I'll say unreasonable, for the inspector to act on the basis of this information, let's say 2 days after he inspected and found no evidence of carbon monoxide poisoning at the mine. So there is no remedy for the mine operator?
Well, there's expedited review. The mine operator can seek expedited review.
So here we know he sought it,
yes,
and it was denied, and the equipment was denied, or he was denied access to the equipment for a month.
Yes, that's correct. But
So,
it is an option to pursue. I'm sorry, go ahead.
Go ahead.
It is an option to pursue expedited review, and it's not the secretary's position that any order after it's terminated is unreviewable. And the agency does need to act reasonably.
How would you get review when you're arguing today it's moot because it's been terminated?
Well, I do think that it could fall within an exception to mootness, though it's our position that it doesn't here, which I will get to.
Even though subsequent accident orders have been issued against this mine operator?
I don't know that I understand the question, Judge. I'm sorry.
I thought you were saying it could come under an exception of capable of repetition yet evading review.
Yes, it could, although
we know that subsequent orders have been issued against the operator.
Yes, subsequent orders have been issued and they haven't been challenged and they've been terminated, which I also think suggests that to the extent that M-Class argues that their reputation is harmed, it's unclear why this particular order would create a reputational injury.
Well, let me just hypothetically say what the operator is concerned about is he's been without his equipment for a month. All right, and it's all well and good, that the order has been terminated and now vacated. But he has no way to get the agency to act because he did seek expedition.
Yes, the agency must be reasonable in its exercise of its power under Section 103K. I'm sorry, I see I'm over my time.
Please continue.
The agency needs to be reasonable in its exercise of 103K power. That's what abuse of discretion review requires. But if I understand your question correctly, I apologize. I don't know that I understand your question.
All right, why don't we hear from counsel?
Well, I have two questions.
Oh, sorry, Judge.
Yeah, I have two questions. First of all, what is your position with respect to vacating not only the commission's decision, but also the ALJ's and the order itself, if it's moot?
If it's moot, we would ask that this court require the commission to vacate it to dismiss the case for lack of jurisdiction, and then that would require, I think, the commission to require the ALJ to dismiss for lack of jurisdiction as well, and then the order would be would be valid and unchallenged.
It would be well, the order would be vacated. If you can't challenge, we have precedent saying if an administrative agency issues an order and it can't be judicially reviewed because of mootness, the order has to be vacated.
I think that here the order would have been terminated already, and so that would
How do you
resolve
draw
that.
this distinction between termination and vacating? I'm just wondering whether we have a case or controversy. You want the order vacated. It seems to me if the case is moot, the order gets vacated. And the mine wants the order vacated. And if the case gets moot, the order gets vacated. So you both win.
We don't want the order vacated. We'd like the order validated.
Okay. All right. The next question I have, and the last one is there any provision or any practice, we're worried about reputational injury, to vacate when there's mootness, to vacate not only the commission's decision, but also the ALJ's?
I think that if the commission's decision is vacated,
I don't mean vacate, I'm sorry, expunge. Expunge the commission's decision, expunge the ALJ's, because that's public knowledge, and anybody reading it would think, well, maybe something happened. Who knows?
I don't know whether there is, Judge. I'm sorry.
Okay.
Don't you want to go even more basic than that, Judge Randolph, to the 103K order itself?
Yes. Yes,
us.
exactly.
Yeah.
That's what I was trying to get to. Yeah.
So
Okay.
I apologize. I think that the vacature would expunge the order, but vacature would also suggest that the order was invalid as issued, and it's our position that the order was validly issued. And so when an order is validly issued and then terminated.
No, because if we issue an order saying the case is moot and you know what the consequences of that would be, anybody who really cared about it would know that the order was vacated not because it was valid or invalid, but because the case was moot.
Well, we wouldn't ask for the order to be vacated. Our position is that the order is valid and that the proceedings should be dismissed as moot.
Okay.
All right. Counsel for respondent.
Morning. May it please the
Good
court.
morning.
Justin Chandler on behalf of respondent, M-Class Mining LLC. I want to first briefly touch on the issue of mootness and why we believe this case is not moot. First, outset, M-Class has sought vacatur of this order. When it filed its notice of contest, it sought for the order to be vacated. Then it moved for an expedited hearing, which was denied. So the Secretary's position that this order being terminated somehow renders it moot, we disagree with, because termination simply means that the condition no longer exists, whereas vacatur is appropriate remedy for the operator when the order was erroneously issued, which we believe, and the commission held, that this order was erroneously issued because it was not predicated on the occurrence of an accident. As far as the standard of review,
Well, can I just ask you a preliminary question then? As I understand the Secretary's position, she appreciates the fact that initial understandings of a situation can change when the inspector conducts an examination, but that the purpose of the 103K order is to essentially assert the Secretary's authority for that period of time until the inspection is continued and the Secretary knows basically where she is. So why wouldn't we defer to that interpretation of the Secretary's interpretation of her own?
Well, two responses to that, Judge Roberts. First would be, we feel like the statutory text in 103K is clear that an accident must actually occur to sustain the issuance of a 103K. And the second, and the commission made this clear in their decision, they were not trying to limit MSHA's ability to respond to apparent accident situations. Instead, what the commission held was MSHA is presented with an incident which may be an accident, which MSHA believes warrants a K, go ahead and issue the K order. However, conduct their investigation, and that investigation reveals no evidence that an accident actually occurred, the appropriate remedy in that situation is to vacate the order because it was erroneously issued. So that would be my two responses to that. But going back to the standard of review, and this kind of ties in as well.
Excuse me, Mr. Chandler, what is the standard that the secretary must follow? You know, I think of the analogy of a search warrant. You don't have to prove that a crime has been committed, just probable cause. And even if a later investigation reveals that the individual is innocent of any offense, it doesn't mean the search warrant was invalid. Isn't that analogy true here?
I think I could draw a distinction this way, Judge Randolph, in that in the search warrant example, the warrant itself may be valid, but the person wasn't charged with a crime. Here, M-Class was publicly, on its public record, it indicates that an accident occurred on February 24th, 2018 at the mine. So it did have, not necessarily penal, but it did have, it wasn't just subject to like the person subject to the search warrant. It was actually subjected to enforcement action as a result of that case. In that portion of the mine was closed for a period of time, and its equipment was voluntarily removed for over a month.
Well, the same thing would happen with a search warrant, and items are seized for a month or 2 months or whatever.
Right. Again, but if I understand you correctly, I think with the search warrant, if they're not charged with a crime, as opposed to here where M-Class was charged on its record with having an accident occurred at the mine, that's how I would try to distinguish the two. Mm-hmm. But again, the second.
So to the extent you were seeking vacator, and that's what the commission gave you, Judge Randolph has suggested, well, is there even a case of controversy? But of course, our orders said address mootness. And my questions basically were focusing on, can the secretary act in a way that basically avoids any judicial review?
Well, I think that's what they tried to do. The secretary tried to do here, Judge Rogers. I think they tried to avoid review by terminating the order and then moving to dismiss on the basis of the termination. However, we feel like the Mine Act provides a further remedy in vacatur because it was erroneously issued. Erroneously issued citations and orders under the Mine Act are vacated, not terminated. In fact, many contested citations and orders in the Mine Act are terminated prior to hearing, before they're ultimately vacated or sustained by the ALJ.
Mr. Chandler, do you have any injury other than the fact that it's still, whether erroneously or not, on the record, other than the reputational? It doesn't count toward anything in your operating history, does it?
That's correct, Judge Henderson. That does not. However, it does remain on the record as an accident occurring, and we believe could be the subject to additional enforcement action to be taken against M-Class. As the commission noted, unlikely here because we're 3 years removed from the incident, a terminated 103 could be later modified, and it could serve as the basis for enforcement action under 104A against the operator. So we think there is harm other than the reputational harm sustained by this order remaining on M-Class's record.
Can
All
you
right,
give
now
me
go
an
through that
example of
again.
Oh, I'm sorry. Go ahead, Karen.
I'm sorry?
What is the collateral effect of this other than, well, reputational?
So the order could, although unlikely in this case, because we're 3 years removed from the incident that brought this case about, it could be later modified. Okay, so a terminated 103K could be modified. So a situation could arise where a retrofit to the compressor, for instance, issue in this case, MSHA could modify that K and demand that the operator implement the retrofit for carbon monoxide emissions, and the operator may not want to do that. So that's one way they could continue to be harmed. And again, the accident remaining on M-Class's public record isn't just a matter of reputational harm. It could factor into the accident if it had been within the most recent 12 months. However, we're 3 years from this incident, so that's no longer an issue for M-Class specifically.
Well, in this case, correct me if I'm wrong, and I need to be clear on the chronology. After the inspector determined that no accident had occurred, as he originally thought, based on the doctor's statement, the operator was still required to prepare a plan. And the first plan was not satisfactory. The second plan was not satisfactory. So if in fact the inspector found there was no accident, then what was the basis for his requiring the operator to come up with these plans? Or is that just a standard operating procedure of any time an inspector looks at a mine, he has the authority or she has the authority to require the operator to provide, a plan for safe operation?
Judge Rogers, we believe that that was absolutely an unreasonable action by MSHA in this situation because the inspector's investigation didn't reveal any evidence of carbon monoxide exposure. So all the evidence that he discovered rebutted what was in that initial escalation report from the doctor. He didn't have any corroborating evidence whatsoever to base the modifications and take as a matter of fact, he tested the compressor underground before issuing the modification, taking it out of service. So MSHA knew the night after the order was issued or hours after the order was issued that the compressor was not emitting elevated levels of carbon monoxide. They didn't have any reasonable basis to remove the compressor for service, and they certainly didn't have a reasonable basis to keep it out of service for a month.
What was the plan? What was the substance of the plan that was required?
The substance of the plan, and that can be found, I believe, in JA 14 through 17. The substance of the plan essentially was MSHA was wanting to make M-Class put in additional measures when using their compressor, which either A, they were already required to do so by law, or B, in response to this particular event, they didn't know what they could do to prevent reoccurrence because there was no evidence that the event occurred. So essentially, MSHA, the only thing that MSHA wanted in the plan was basically what M-Class was already required to do by law. That sufficiently answers your question. I'm sorry.
Thank you. Yes, no. Do my colleagues have anything further?
I don't.
No.
Anything further, counsel? No? Thank you. All right. Let us hear from the secretary.
Thank you. Just a few points to make. I want to address the argument that a terminated K order could be modified to impose additional enforcement actions. That's not the case. A terminated K order cannot be modified. The commission suggested that it could, and then cited cases that have to do with Section 104 citations and orders, which can be modified following termination. Often they're modified in settlement, I think. But a 103K order, the purpose of the 103K is to give MSHA control over the mine. And so once that order is terminated, that means that there's no longer a need to have control over the mine. And there's nothing further that can be modified. So there's no risk that MSHA would go back and modify this terminated K order. And I think
what is the nature of these plans that were required?
I think that there was a discussion between the operator and MSHA, on these plans. And I'm under the impression that the operator wanted its equipment back, and MSHA was proposing intermediary measures while it conducted an inspection of the equipment. I'm afraid I don't know.
But this lasted over a month.
Yes, and the inspection of the equipment lasted over a month. It's not the case that MSHA knew immediately that the equipment wasn't emitting carbon monoxide. And I don't know that MSHA ever conclusively, I don't know that MSHA concluded that the equipment certainly wasn't emitting carbon monoxide, that they conducted a thorough investigation. They were under the impression that the air compressor because it was a diesel-powered air compressor, was likely the source of the carbon monoxide poisoning. And so for a month, they conducted these tests. They did not
And
want
what
to
were
put.
the plans?
I'm afraid I don't know the details of the plans, Judge, but I think that
No, I don't
that's.
need details, but why were the plans required if it was just a matter of MSHA doing the investigation?
I think that typically, in the context of a 103K order, there is back and forth between the operator and MSHA about intermediary solutions. I think that that's standard, although I'm afraid I don't know the details.
Well, you know this case, right?
Yes.
What happened here?
I'm not clear on what MSHA spoke with the operator about or would have required, but I do know that the operator insisted on having its equipment back, and MSHA wasn't willing to release the equipment to the operator until.
No, I understand all that, but it also, according to the brief, said that the operator submitted one plan that wasn't satisfactory. He submitted another plan that wasn't satisfactory.
Yes, I don't know the details of those plans.
Well,
Judge.
would
I
that affect our
apologize.
analysis of mootness at all?
No, I don't think that it would. And then just another point to make.
I mean, I'm just trying to press you so I understand how far the secretary goes on this. Suppose I'm the mine operator and I want my equipment back. And the inspector says, yes, but I need a plan. And the inspector says, I want the plan to have 5 things in it. And I say, that's going to cost me $500,000. The inspector says, I want that plan. And you don't get your equipment back until I get that plan. I just want to understand what's happening in this situation. It may be fine that the inspector needs a month to test the equipment, but it's not the same as requiring the operator to come up with a plan. It's a safety plan.
I think that it's an intermediary plan. I think that it's.
But we don't know. Okay.
No.
So all we can do is look at 1417 of the record and see
That's
what's
right.
there.
Yes. Yes, and I apologize about that. And then I just briefly wanted to address the fact that the commission does say, and Mr. Chandler referenced this, that an inspector acting in good faith could issue a K order under these circumstances if it were later vacated, and that doesn't make sense for a few reasons. The commission's holding is essentially that MSHA doesn't have authority to issue a K order at the outset of an accident unless information becomes available later that suggests that there was, that concludes that an accident occurred. And this is a significant limitation on MSHA's plenary power under 103K. And, I think I may have made this point earlier, but vacatur implies that the order was erroneously issued and that the inspector should have done something differently. But I think that all parties agree. Oh, I apologize. I see that I think I may be over my time.
You want to finish your sentence?
Yes, thank you. Vacatur implies that the inspector should have done something differently, but I think all the parties agree that the inspector acted correctly here. And finally, the fact that the commission would allow an inspector to issue a K order as long as he later vacates it suggests that the agency would be required to engage in unlawful action repeatedly and then erase it somehow, and that doesn't make sense.
So understand or provide me with an understanding of what happens if we dismiss this case as moot, and the discussion that Judge Randolph was having with you, we would vacate. I don't know. I don't want to put this in the judge's mouth, but what would happen to the commission decision? What would happen to the ALJ decision? And where does the mine operator stand?
So the commission decision would be dismissed for lack of, would be reversed and dismissed for lack of jurisdiction. And that would happen to the ALJ decision as well. And then.
So they're both on the books.
Yes.
So if the mine operator in the future is subject to a 104 enforcement action, this history is relevant.
Well, a terminated K order would be on the books, but that isn't, the terminated K order wouldn't have an effect on any enforcement under 104. You know, it wouldn't contribute to any penalties. It wouldn't be taken into account. It's just because it's terminated, there's a record that it occurred and then was terminated. That's the only consequence. And that's, I think, how it would stand once the
So the operator doesn't get the record cleared.
No.
Unless we vacate the 103K order.
Yes.
Thank you.
Thank you.
Thank you, counsel.
Thank you.
Anything further? Counsel?
No, thank you,
Judges?
Judge.
All right, we'll take the case under advisement. Thank you.
Thank
Case number 20-7033, Mykola Ivanenko et al., appellants versus Victor Yanukovich et al. Mr. McCallion for the appellants, Mr. Shaw for the appellate government of Ukraine.
Good morning, counsel. Counsel for appellants, do you wish to start?
Yes, good morning. May it please the court, Kenneth McCallion for plaintiff appellants, Luke's Express, the Alamo Group, also including Mr. and Mrs. Ivanenko. We believe the district court's decision and order should be reversed as to all appellants. However, we believe the clearest case for reversal is as to the Alamo Group, since there is obviously no domestic taking issue there. The Alamo Group was and is a U.S. Georgia-based corporation and a de facto joint venture with Luke's Express in a automobile sales operation, import-export operation, located in Kiev, Ukraine. The Alamo Group had offices there in Ukraine, just as Luke's Express had offices in Atlanta, Georgia, at the Alamo Group's offices there. And in addition, the Alamo Group maintained in the Ukraine property certain automobiles, auto parts, and other inventory, which had been imported into Ukraine from the US. In July of 2012, the buildings were destroyed on that property, and also valuable property was taken by agents and instrumentalities of Ukraine at the direction of an instrumentality, an agency of the Ukraine government, Southwestern Railway. At that time, property was taken from the Alamo Group, and this was in violation of international law, not only because they weren't compensated, but it was in direct violation of a bilateral treaty between Ukraine and the United States, whereby Alamo Group and other US companies were induced or reassured to do business in Ukraine, that there would be a judicial remedy available to them in the event, as what happened here, property was taken and expropriated. Ukraine's position, and apparently that of the district court, was that the Alamo Group, this US company, does not have recourse under the bilateral treaty, which by its language permits an agreed party recourse to the courts of a party to the treaty, Ukraine or the US. And in this particular case, the Alamo Group, as well as the Ukraine defendants, it did not have adequate recourse to the Ukraine courts, because at this particular time, both the courts and the government were controlled by a pro-Russian, anti-US and anti-Western European government that discriminated against US companies, and the judicial system, the rule of law, was not vibrant at that particular time, since the courts were, as well as the government, was subject to rampant corruption and political influence on the judicial system. So the taking here for purposes of the commercial exception to the FSIA was not, as the district court found, erroneously found, unfortunately, that the taking was for a public purpose, the construction of a bridge. However, as we argued in our complaints as well as in our papers, while the ostensible purpose was for the building of a bridge, this was a subterfuge, and indeed a bridge was never built, but it was a subterfuge for a commercial purpose, namely the taking of the property and its use for for-profit commercial activity, a sports arena for the personal benefit of some of the individual defendants. The taking here of the Alamo Group's property, as well as that of Luke's Express and the Ukrainian individual plaintiffs, had a direct effect in the United States, which, as the case law indicates, must be more than trivial. In this case, the financial impact was devastating, both on the Alamo Group and Luke's Express, which maintained an office in Georgia and had to close that after the destruction of its property in Ukraine. The Alamo Group was in essence the controlling party of the Ukraine company, Luke's Express, through various loans and financial arrangements, which of course Luke's Express could no longer fulfill those obligations. And this led to a devastating cascading effect on Alamo Group, which had significant lines of credit secured by property in the United States. And it was its business was virtually destroyed. The lion's share of its business was with this Ukraine operation, which was completely destroyed, and the inventory taken in July of 2012. I would like to point out that the defendant here, Ukraine, of course, takes the position that this was a domestic taking. We can't apply that argument to the Alamo Group, but it applies it to Luke's Express and the individual defendants. However, we would point out that we believe the only way that the bilateral treaty can have any teeth or any impact would be for Alamo Group to have a judicial remedy, and also that Luke's Express and the individual Ivanenko plaintiffs who are in the US, they sought asylum after death threats were made against them in Ukraine, that they also have a judicial remedy, and that the government of Ukraine really cannot have it both ways. Under a presidential decree actually addressed to this case and one similar case, it issued a presidential decree in 2016 saying that Luke's Express and the Ivanenko individual plaintiffs would be considered as foreign entities for purposes of this litigation, which they had pending in the US District Court. And Ukraine argues, well, we call them foreign entities or foreign persons for purposes of this litigation so that the Ministry of Justice could defend the case, but for all other purposes, they are Ukrainian plaintiffs. We would argue that the government cannot have it both ways, that when it defined by statute or presidential decree these originally Ukrainian plaintiffs as foreign entities, if they want, the object could have been otherwise, but in a sense, they were declaring these to be persona non grata, no longer could have the benefits of Ukrainian citizenship. And we believe that they should be treated as foreign entities, not domestic Ukraine entities for purposes of this litigation based upon the actions of Ukraine. I'd also
All right, well,
like
counsel, as you know, the Ukraine has argued both the domestic taking exceptions and the failure of the Alamo group to meet the commercial activities exception. And of course, the Supreme Court more recently has cut back this court in terms of exceptions. Any comment you want to make on that?
Sure. We didn't brief the most recent decisions. However, in the Phillips case and in the Simon case, which is back either before the district court in your district.
Well, let's put it this way. The
or in the
appellate
appeals-
court is going to look at the law as it is now.
Sure. The law as it is now, the primary takeaway I see to the Phillips case, we never argued that this was a human rights case. We argued that it was strictly a property case. So certainly we're alive and well, I think, under Phillips and Simon in that respect. The taking of the property should only be viewed under the lens of the property law. And in this particular case, if you look at both the exceptions under the commercial taking, the commercial activity in the taking section, we believe that we fall within both those exceptions, as I indicated, under the commercial activity. And I think this is an important point, which the district court kind of missed, and the Ukraine has really picked up on that improperly. While the land itself may have been owned by the Kiev City Council, it's clear from the record that it was the Southwestern Railway, clearly an instrumentality, an agency of the Ukraine government that had been tasked to operate this particular land and indeed to negotiate with the defendants over compensation. They actually arrived at an agreement for compensation, but those monies were promptly stolen from the Ukraine Treasury by individual defendants and was no longer available. So it was clearly the commercial activity both before and after the taking. It was an automobile dealership before, after. It wasn't used for a public purpose, the building of a bridge, the off-ramps, it was the bridge never happened, at least with regard to this property. What it was used for was a for-profit commercial sports facility.
All right. Well, why don't we hear from counsel for Appellants? I think it's a nice segue from those recent Supreme Court cases.
Good morning.
And then we'll give you some time on rebuttal.
Thank you.
Good morning. May it please the court, I'm Robert Shaw of Holland and Knight on behalf of Ukraine. The district court correctly held that this case does not trigger any of the FSIA's narrow exceptions to foreign sovereign immunity. I'll begin with the expropriation exception, because that was the initial focus of appellant's oral argument. It only applies where property is both taken in violation of international law and that property has a certain nexus to the United States. The appellants who allegedly suffered a taking of their leasehold and the destruction of their property, real property, were Lux Express 2 and Mr. and Mrs. Ivanenko. They are Ukrainian, and as the Supreme Court explained only last month, the domestic takings rule holds that expropriation from a country's own nationals do not violate international law and therefore do not trigger FSA jurisdiction. Appellant's principal argument on appeal is that this court's decision in Simon versus Republic of Hungary and other cases once recognized an exception to the domestic takings rule for takings attendant to genocide. And appellants made the argument that this genocide exception ought to be expanded to encompass discriminatory takings and argued that this was somehow a discriminatory taking. As Judge Rogers alluded to during appellant's argument, that entire basis was foreclosed by the Federal Republic of Germany Phillips case, where the Supreme Court held that there is no exception to the domestic takings rule for even genocidal takings. So there cannot possibly be one for merely discriminatory takings. Now, the second argument is that Alamo Group, an American company that allegedly did business with Lux Express 2, should be treated as though it were the parent company of Lux Express. Now, this court has recognized that an American parent company can suffer a taking in violation of international law if all of the assets of its wholly owned foreign incorporated subsidiary are wrongfully seized by a foreign government. The problem with this argument isn't the law, it's the fact that Alamo Group is not alleged to have had any ownership interest in Lux Express 2 at the time of the alleged expropriation. Lux Express 2 was wholly owned by Mr. and Mrs. Ivanenko, two Ukrainians. So the domestic taking rule eliminates the application of the expropriation exception to almost this entire case. The plaintiffs or appellants have resorted to a last-ditch argument in their reply brief, and they contend that office equipment, automobiles, and auto parts that the American appellant, Alamo Group, stored on the property and jointly shared with Lux Express was wrongfully destroyed and or taken by the defendant. Now, this was not the focus of this case up until very recently, but because there's no place left to go for jurisdiction, a case that started out about real estate in Kiev is now about unspecified automobiles. Now, there are a number of problems with this argument as well. To begin with, there's actually no allegation or evidence that Alamo Group even owned the allegedly shared computers and automobile. So appellants have failed to actually allege a taking from an American company. But in any event, none of the appellants, including Alamo Group, can possibly satisfy the second prong of the expropriation exception, the need for a nexus between the expropriated property and the United States. In order to trigger the expropriation exception, the property has to be either here in this country or owned and operated by an agency or instrumentality of the foreign state that is engaged in a commercial activity in this country. Now, appellants have not remotely shown that a state-owned company owns or operates the land at issue, much less that a state-owned company is engaged in a commercial activity in this country. There's a suggestion that computers, auto parts, and automobiles may have been destroyed by some part of the Ukrainian government. Well, if that's the case, they can't be owned or operated by some state-owned company because they no longer exist. In his opening presentation, appellant argued that this parcel was originally taken to form a railroad bridge, but that the bridge never got built and now it's been turned into a sports complex. Well, the complaint says the same thing, more or less, but what it doesn't say is that the Southwestern Railway, this alleged agency or instrumentality of Ukraine, currently possesses anything from any of the appellants. It says practically just the opposite, that the Southwestern Railway was there as a pretext to seize this parcel and turn it into a sports complex and really has nothing to do with the events at issue. As the district court correctly found, there's also no concrete allegations established that the Southwestern Railway qualifies as an agency instrumentality of the government of Ukraine. It is not alleged to be wholly owned by the government to serve a principally commercial purpose. So we don't We don't have allegations supporting its status as a agency or instrumentality. We don't have allegations supporting the suggestion that it owns or operates any allegedly taken automobiles or anything else. But most importantly, there are no allegations anywhere in the complaint that the Southwestern Railway is engaged in commercial activity in the United States, which of course is the touchstone of the second prong of the expropriation exception. The first time we heard about the Southwestern Railway supposedly acquiring locomotive engines from General Electric was in Appellants' opening brief in this case. And it was accompanied by a request, a far too late request, to amend the complaint to assert these new allegations. Ukraine respectfully suggests that it's a little late in your opening appellate brief to be asking for leave to file an amended complaint, especially where the appellant didn't request leave to file an amended complaint below. Appellants also argue the application of the commercial activity exception, which also doesn't apply. Indeed, Judge Rogers squarely addressed the issue in Wrong versus Liaoning provincial government. In that case, this court held that an expropriation is a quintessentially governmental act and non-commercial in nature. And Judge Henderson, in a concurrence in that case, explained that a mere financial loss by a resident of the United States, in this case, Alamo Group, does not constitute a direct effect in the United States. So we have here an alleged expropriation, that's a non-commercial act by law. And then we have a mere financial loss to an American party, which doesn't qualify as a matter of law as a direct effect in the United States. Plaintiffs also, or appellants also sort of broadly argue the application of the bilateral investment treaty between the United States and Ukraine, and say that unless this case, unless the court is found to have jurisdiction over this case, then the treaty is neutered. Just to quickly explain, a bilateral investment treaty gives foreign direct investors a right to pursue their claims in arbitration. That is the point of that treaty. It does give aggrieved investors the right to also bring court cases in the foreign state. So if you're an investor from the United States and Ukraine, you can bring a claim in Ukraine, but you can't bring a claim in the United States for the purpose of the treaty. Finally, there was some discussion in Helen's opening argument that it was a waiver by virtue of a presidential decree. This gets a little technical, but the reality is that at the time this lawsuit was filed, Ukraine's domestic law didn't contemplate claims being filed against the state in foreign courts by Ukrainians. And so there was no part of the Ukrainian government that was authorized to hire counsel to mount a defense to that sort of unusual case. And so there had to be a presidential decree which made the technical amendment to the statute that recategorized such plaintiffs as foreign for purposes of Ukrainian law in order to authorize the Ministry of Justice to defend this case and another case that was filed at the same time. Finally, the appellants say that the district court erred by refusing to grant jurisdictional discovery. The jurisdictional discovery that was requested, Your Honors, was just completely blunderbuss in nature. He asked for leave to propound discovery requests probing all of the economic ties between the United States and Ukraine, obviously hunting for any possible jurisdictional hook. And it was correctly denied. The court did not abuse its discretion in denying that, that request for relief.
All right.
Thank you very much, Your Honor.
Thank you. Counsel for appellants, give you a couple of minutes.
Yes, thank you very much. I tried to listen very closely, but counsel, I don't think, really rebutted the argument that the Alamo Group, U.S. company, which is not subject to the domestic takings exception, suffered not a derivative loss, but a direct loss, as alleged throughout this litigation, in addition to the taking of the leases, which was the Luke's Express loss primarily. Alamo Group, as counsel I think concedes or alleges that with a foundation in the record that it did have specific equipment and automobiles and auto parts on the premises that were not destroyed, but were taken by the instrumentality, which
Where is
was
that in, counsel, where, can you give me the JA site for that allegation?
I was looking for that, and I believe it's in the reply brief.
No. You said it was an allegation. Isn't it in your complaint? Where in your complaint is it alleged that automobiles and auto parts were taken, owned by Alamo and taken?
Yes, that would be the citation I see is the one I immediately see is the affidavit of Ivanenko, which is A361, where it says that Alamo Group maintain automobiles, auto parts, and accessories, which were stolen by the defendants. I don't immediately see the reference to the complaint, but this is from the affidavit that was submitted in support of the opposition in the court below. We then offered a second amended complaint, and so the references that I can immediately see are in the affidavits of Ivanenko at A361 and Mark Resnick at A354. And I believe they cite to the complaint, but I don't immediately have the the complaint cite to it. If I could supplement the record, I will go through the complaint and get that. Shall I proceed? The taking of the Alamo Group's property clearly outside the domestic taking falls within both the commercial activity exception and the takings exception. Under the commercial activity, it had a direct effect on the United States. The transactions were in dollars between the parties. It impacted the Federal Reserve System, and it devastated Alamo Group's business in the US. Now, the Southwestern Railway, which counsel alluded to, and I did as well, after the district court decision had been rendered and we were in an appellate context, it came to our attention and we put it into our brief, the public citation to a commercial railway purchase by Southwestern Railway, which of millions, if not billions of dollars of locomotive equipment from GE here in the US. And under the commercial activity definition under 1303D, commercial activity can be a continuing course of conduct, or it can be a single act. And we would argue that we have established through the public record here that purchase by Southwestern Railway. So the focus here is not so much on the leases itself, which would be part of the claim of Luke's Express, but on the taking of the personal property of Alamo Group, which itself suffered damages, not derivative damages. We believe that the court, there is no claim here of genocide, as counsel says, and clearly we're within the scope of Phillips with regard to a property damage exception. And Phillips was remanded for further consideration as to the nationality, which we believe is an open issue here, and we would respectfully request that the matter be remanded for further proceedings so that in fact counsel, which is that appellant, which has set forth a good faith basis now of a commercial activity by Southwestern Railway, which first became publicly aware of that while we were on appeal here, that the matter should be remanded. We did not sit on our rights. We raised it here.
All right, counsel.
In the appellate context.
Yes, I think we get your point. Unless my colleagues have any questions, I think we'll take the case under advisement.
That's fine.
Oh,
Thank you.
thank you, counsel.
This honorable court is now adjourned until Tuesday, March 23rd at 9:30 a.m.